Hello, everybody, and welcome to today's webinar. We're going to be discussing a very important topic today. Many of you on today's webinar, it's great to have such a good attendance today. I'm sure there's many of you that are already portfolio landlords, or you do already have properties within your portfolio. So I think this would be a really good operation to discuss what's actually happening on the ground. And I'm very happy and proud to welcome Raj onto the webinar today from Martin & Co. He's the director there, and I'll be introducing him a little bit later to talk to you about these changes and what's actually happening to landlords on the ground. So a little bit about myself. My name is Travis Comery. I'm the Senior Investment Manager for Joseph Mews. I've worked in both ends of this kind of spectrum. So I've worked on the ground in the UK running a very successful lettings business. So I'm very familiar with the back end of this journey. So that's about how to find your tenants, how to qualify your tenants, and how to kind of make sure that your property is being managed in an appropriate manner. I've then moved to Joseph Mews, where my role is now to guide and advise clients all around the world on where to buy, why to buy, and how to make this a investment, how to make this investment as successful as possible. So as you can see a few kind of figures on the screen here. I'm very fortunate to be able to with you and to introduce you to Raj, who's going to go into a little bit more detail of exactly what this renters reform bill looks like for you. So just to give you a brief itinerary, I guess, on what we're going to cover today. So firstly, the big picture, which is understanding the structural shift in the UK. There is definitely changes to be had, and there are definitely rules and regulations that are different now. So it's very important to understand those. And I think also what we're going to lean on the webinar today is the importance of having a professional background behind you who are going to support you through that side of the journey. Number two is the eviction overhaul. So that is going to be discussing the Section 21 abolishments and the new grounds. So if you have a bad tenant, how are you going to evict that tenant? What is the process when it comes to getting somebody out? We then have periodic tenancies. So that is, again, I'm sure many of you will be aware, but that is that we are now in a position where we don't have a fixed AST, assured short hold tenancy agreement. We are on an immediate periodic rolling contract from the start. Okay, so we're going to discuss what that looks like and how that is not as scary as it looks on paper. We then have the compliance and standards. So we're going to go into a little bit more detail on the standards and the compliance elements of the change, which again, look, is very important for you to know, not necessarily too important for you to have too much detail on, because again, that's why a successful letting agent are in place, and that's their job in terms of looking after you from a representation point of view. We will then discuss your action plan. So talking about deadlines and talking about the next steps to protect your investment. And if you're in a position at the moment where, for example, you're coming up to completion on a property, how we can best utilize the new renters reform bill to get you a tenant quickly. So we're going to kind of make sure this whole webinar today is interactive as possible. This is your opportunity. We're live. So this is your opportunity to ask questions. This is your opportunity to speak to myself, to speak to Raj, who I'm going to introduce in a moment, and really go into the detail of the renters reform bill and what exactly this is going to look like on the ground for you as a landlord. So a little bit about us at Joseph Mews, and this is something that's very important for us to share. So as you can imagine from today's webinar, this is all about the renters reform bill. It's about providing a level of education to our clients around the world. Okay, so what we are is we're a property investment business, and what we do is we provide a full end-to-end service. Okay, so we start with advising you where to buy, why to grow a portfolio in the UK, what the benefits are to having assets within the UK, leveraging and utilizing a small amount of cash to build a sustainable and safe portfolio. We then go a little bit further, which we then discuss kind of your strategy. So we go into how to buy your properties, how to leverage, how to release equity, and how to grow this portfolio for you. So essentially, we will act as your advisor for your journey of buying. Okay, we will introduce you to legal supports. We will also introduce you to then the letting agents on the ground in the UK, like Raj and his team at Martin & Co. So when we get to the end of your purchase, where you are now coming towards completion, we're then in a position where we can put you in touch with the professionals who are going to find your tenants and carry you through a full management service. Okay, so in order just to kind of summarize what we do at Joseph Mews, we basically guide you through this whole journey of buying in the UK. Okay. So proven delivery and end-to-end support. So as I mentioned, in terms of our track record, we've delivered over 4,000 units as a business. So we're very consistent in our approach. We've done this a long time. You're not dealing with an entry kind of business into the market. We've delivered a lot of units in the UK. We know all of the holes. We know everything that's kind of going to potentially come up as a problem. We know exactly how we can make this work for you. And we are here to give you that advice and that advice and that level of support. I think what's important for me to mention on this screen here is that the repeat clientele retention rate. So you can see that 28% of our clients will buy again. Now, the reason that's so important is because when you're looking at a UK property as an asset, there are many ways to grow that portfolio, even by relinquishing and using the same cash that you initially employed to grow and repeat and recycle and end up with where you've got 4 or 5 properties in a very short amount of time, which is great for your longevity. It's great for retirement planning, legacy leaving. If you're looking for that longer term investment journey, the UK property is a fantastic way to do so. And my job and my job on behalf of Joseph Mews is to guide you, is to support you and be an advisor and give you exactly what you need to know about UK property. But as I mentioned, the end-to-end service includes letting agents and people on the ground. And that is from experience, I know this is probably the most important part of your investment. Okay. It's not about where you buy. Every property in the UK is going to grow in value and every property in the UK is going to rent. Okay. We've seen the statistics all over the country. We know that the UK property market is buoyant, it's popular, and it's moving forwards fast, and it's doing so in a very good light. However, what's important is when you get that property that is completed, that you have professional oversight. You have a business that are looking after your properties in the right way. They are doing their inspections. They are totally up to speed with legislation. They are giving you the best possible service to give you the comfort that your properties that you've invested a lot of money into are being looked after on the ground. So again, that's a very important part of this journey, and that's why we're doing the webinar today to support you in terms of giving you the education that you need around the Renters Reform Bill, but also hopefully giving you some comfort that legislation changes happen all the time in the UK. It's just how we adapt. That's all this is. It's not to say that this is negative or it's a problem. It's just how we adapt to make this a position where you are comfortable and you are looked after as a landlord of ours. Okay. So this part's very important because look, we want this webinar, myself and Raj, to be as interactive as we can. Like I said, we're committing the best part of 30, 40 minutes today, and we want this to be interactive. We want you guys to ask us questions. We think it's very important for you to feel as if you're comfortable enough to ask us these questions on a webinar like today. The whole point is that hopefully you're going to come away from this webinar with some understanding or some more understanding on the Renters Reform Bill, and hopefully feel a little bit more comfortable with what's actually changing in the UK from a legislation point of view. So as you can see here, step 1, we have a Q&A box at the bottom of your screen. If you just click the Q&A box at any time during the webinar, we can answer them either live or at the Q&A session that we'll have at the end. But like I said, it'd be really good to keep this as engaging and interactive as possible. So it'd be great to hear your thoughts throughout the webinar. So I'd like to now welcome Raj onto the screen. So as I mentioned, Raj is the director at Martin & Co. and the Radar Property Group, extremely experienced and on the ground in the UK. And he's going to go through the next few slides for us in talking to us exactly about this change, what's happening at the moment and and hopefully, like I said, giving you some confidence in terms of this legislation change, that it's going to turn into being pretty much standard practice. But Raj, if you'd like to just introduce yourself and I'll let you take it away.
Thanks, Travis. Hello, everybody. So, my name's Raj, and I'm the franchise owner of Martin & Co. So, Martin & Co is a franchise in the UK, an estate agency franchise with over 150 offices, and I've got 2 offices in Birmingham. So my main kind of knowledge of the property market is within Birmingham, but because we've got so many franchisees across the UK, I kind of hear from other franchisees about the markets in different parts of the UK. So I'm going to talk to you about the Renters' Rights Act and kind of the different things that have been implemented within it and how that can affect you as a landlord. Now, the next slide, please. Okay, so the Renters' Rights Act is the most significant change in decades in the UK. So probably the previous change we had was in 2019 when we had the Tenant Fees Act, and essentially what that was tenant fees getting banned, but this is a bigger change than that. So what the government have intended to do is for tenants, they're wanting to make what they believe is a fairer and safer and more transparent way of renting across the UK. And the way they've essentially done this is by banning or, withdrawing AST fixed term contracts. So what you have now is assured periodic tenancies, which are essentially they're rolling from day one. And these changes came into effect on the 1st of May. And importantly, it doesn't just affect new tenancies, it also affects existing tenancies. So every tenancy prior to the 1st of May, even if it was fixed term, so a tenant could have signed a fixed term on the 30th of April, on the 1st of May, suddenly that tenancy becomes rolling. There's quite big penalties in place for non-compliance, ranging from 7,000 to 40,000. So it's quite serious penalties that landlords and agents need to be aware of and need to make sure that they're keeping up to date with the laws and implementing them so that landlords aren't, penalised or agents aren't penalised. And, this affects all landlords, whether you've got one property or a portfolio of 10 properties, this affects everyone. The only thing that falls outside of this is if you have a company let. So if you rented your property to a company, that doesn't fall into any of this. And the Renters' Rights Act does not apply to that tenancy. So a company let, you would still have fixed term agreements of, say, 12 months or 6 months, for example. Now, the next slide, please. Okay, so with the abolition of Section 21, so previously with the Section 21, landlords could give notice for any reason. They didn't need to provide a reason to the tenant. They could just want their property back and serve a notice and get it back. Now it's a lot more that you can still get your property back, but there's only certain reasons why a landlord can get their property back. The main biggest reasons are moving back in, or a family member moving in, or the landlord looking to sell. But they can't use these grounds in the first 12 months. So if you have a tenancy start on, let's say your tenancy started on 1st of June, and 6 months later you decided you wanted to sell, or actually, you need to wait for the 12 months because that tenant has got security for 12 months. Although if they decide that they want to give notice, then that's fine for them to do it. But, you just need to be aware of the landlord. If you're renting your property out and you're thinking you may want to sell, you've just got to bear in mind that first 12-month period. So whilst that does make it more difficult for landlords, actually them grounds are probably the most common grounds that a landlord would want to get their property back anyway. It's very rare that, a landlord just wants their property back because they've fallen out with the tenant, or, they're not keen on the tenant and they want a different tenant. It does happen, but it's not as common. So it's not the be all and end all. It's a change, but I do think it protects landlords under the most common eventualities of why they would want their property back. Also, the arrears threshold has changed. So prior to these new laws, the tenant was in 2 months arrears, you could serve notice to get the property back. Now you have to wait until the tenant's in 3 months arrears. So yeah, it does make it a bit more difficult for landlords. It gives the tenant essentially, an extra month while that kind of you're evicting a tenant, and that eviction procedure, it will take an extra month than what it used to. There's certain grounds that are tailored for student properties, because student properties is more kind of seasonal, and you have the tenancy start in the summer and end in the summer. So there's separate laws that kind of protect students and student landlords in that. I won't go too much into that because one is I'm not a specialist in student tenancies, and the other is most landlords or people here today are probably not buying HMO type student properties. Can I have the next slide, please?
Yeah, Raj, just to add there, I mean that was some great points that you raised in terms of this change, and I guess just from my experience, as I mentioned at the start, I've worked in the residential lettings market on the ground for 8 years of my career, and What I'd just like to add is that while there are many bad tenants that you always hear about, you always have these horror stories about the bad tenants that exist, blah, 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 blah. There are also some bad landlords out there. Okay. And there have been situations in the UK where there's been some pretty terrible landlords that are treating their tenants terribly. So what this legislation, I guess, is doing here is to try and find some form of common ground to protect both the tenants when they've got a bad landlord and they're just getting kicked out onto the street without any kind of protection for their future or the children if they're in a local school, while also still having this solid kind of period, for example, at the 3 months where we can initiate an immediate an eviction in a firmer way. You know, at 3 months, yes, it is a little bit longer, but it can be firm, it can be quite precise, and it can be actioned quickly. So, look, like I said, I just wanted to add there that the reason, the main reason why this has been brought in is because even though I'm sure everybody on today's webinar, if you are already a landlord, you're probably a pretty good one, but there are some bad ones out there, and that's the reason why they're trying to find a common ground and a reason to protect. So yeah, just thought I'd add that one in there, Raj.
Cheers, thanks for that, Travis. So yeah, with the end of fixed term contracts, so every tenancy now is an assured periodic tenancy. So essentially it means that the tenancy is rolling from the outset. Now, a tenant has to give 2 months notice. So essentially a tenant could take a property and then, they move in and the next day they give their notice. Now that notice wouldn't take effect until the next rent due date. So essentially their notice would take effect from month two. So they would essentially have 3 months in the property. Now that is a concern for many landlords that they could just get a tenant and they move out within 3 months. I would say, whilst this has only been in place for a month in the UK, so there's not much we haven't got that much experience with it. These laws have already been in Scotland for a number of years. And speaking to the offices that we've got in Scotland within Martin & Co, they said that is very, very rare for a tenant to ever do that. So I don't think it's something as a landlord to be worried about tenants just moving in and giving notice straight away. As long as a landlord you are providing good accommodation and responding to maintenance issues well and all of that, there's no reason really for your tenant to leave. So I think now is a more important time than ever for landlords to make sure that they're giving the best service possible to their tenants to make sure that their tenants do not want to leave.
Yeah, I think that that goes on my point as well, Raj, quite nicely because at the end of the day, there's tenants, they crave stability. Okay, you've seen this, I've seen it from my experience. They crave stability. There is not many tenants that are going to kind of move into somewhere and want to leave straight away. There is a reason why they are renting your property. And if you are the right type of landlord that cares about the property that you're providing for your tenants, you won't have a problem. And this is again, my point was that I was trying to suggest that they're trying to cut out the bad landlords in this world, the ones that don't care about maintenance, the ones that haven't updated their property for 15 years. Okay, these are the people that they're trying to protect. If you are a good landlord, you care about your property, you've got a good agent that'll be very responsive to the management requests that are in place. The likelihood is that, like I said, tenants will crave that stability and they will want to remain long term. We're also in a marketplace where there's not many rental homes available on the market, right? Compared to the demand. There is a lot higher demand compared to availability. So again, that hopefully relinquishes and alleviates any concern that these guys, these tenants, if we're finding the right tenants, which I'm sure Martin and Co and they have done for many years for us as a business, if you're finding the right standard of people, the likelihood is that you're not going to have that problem with them leaving soon, unless there is a genuine reason, sickness, health, whatever that comes into play. So again, I actually think this is a really good thing for the rental market. I think it's very positive, and I think it's something that's come in and I think the positive spin on this is very important to note. Raj, we've had a question. I think it could be good to answer at this stage, which is, hello, if your tenant moves out and didn't give the required 2 months rent notice, are they obliged to pay the rents in lieu since they didn't give the needed notice?
Absolutely, yeah. So the tenant has to stick to that notice period. Obviously, as a landlord, if you want to agree a lower notice period, you can do, but you don't have to. The notice period it is 2 months, and it runs in line with the rent date. And essentially, you will hold that tenant to that agreement. If the tenant didn't pay, let's say the tenant wanted to just give one month's notice, and they just said, right, I'm only paying 1 month's rent. I'm not paying the next month's rent. It's not ideal, but you could then use the deposit to use for deduction for that last month's rent, which isn't ideal because really the deposit's not there for rent. The deposit's there for damages or cleaning at the end of the tenancy. But you have already got that deposit there as a backup, which can be used for rent arrears. And essentially, if they don't give the right notice period, they would therefore be in rent arrears if they haven't paid that final month's rent. Just going on to what Travis said as well, I think it's very clear that tenants, they can't just they don't want to just move up and move into a property and move out quickly, because the amount of extra costs involved for that tenant and the hassle involved for moving property to property. You've got so many hidden costs that you wouldn't think about in terms of removal vans and cancelling broadband, setting up broadband, and just the hassle of moving and taking time off work to move, and also paying. You don't get your deposit back from one tenancy until maybe a few weeks after, and then you've got to pay a deposit and first month's rent on another property. So I don't think there needs to be the worry that tenants want to just keep moving. They want security. More now than ever. Tenancies are lasting longer than they ever have been before. So there's some good news in that. And I think the good landlords will benefit from this, because the rogue landlords, the landlords that aren't looking after their tenants, they're the ones that are going to lose out. And all them tenants are then going to go towards the good landlords. So I think it's a great opportunity for good landlords to benefit from this.
Yeah, totally agree.
So this obviously came in 1st of May. There's no new tenancy agreement needed to be signed for this transition. Automatically, the tenancy agreement just converts into an APT, which stands for Assured Periodic Tenancy. Now, there is something that landlords and agents need to be aware of. So all tenants needed to be served before the 31st of May with a Renters' Rights Act information sheet. And there can be fines up to 7,000 if this wasn't done. Now, if you have an agent, I would say 99, I'd say really 100% of agents would have done this for you. But, I can't, any reasonable good agent would have. If your agent didn't do this, then you really need to question the agent that you've got, because they're just not doing their job properly. But I think it's safe to say that 99% of agents in the UK, I would like to think, would have done this for the landlord. If you're unsure, reach out to your agent and just double check. If they haven't done it for whatever reason, I would say, yes, we are past the 31st of May deadline, but still just serve it. It's better to serve it, at some point, even if it's late, than never to serve it at all. So yeah, I would always just double check with your agent that they have done that, but I'd like to think they would have. Obviously, if you're a self-managing landlord, you should have done this yourself. If you haven't, just get it done now. Have the next slide, please. Okay, so the way rent increases are managed, that's changed as well. So previously we had fixed term contracts, let's say it's 12 months, and what happened is at the 2 months away from the 12-month tenancy ending, it was a reminder to we need to draw up a new tenancy agreement and review the rent at that stage. Now that's changed now, so because we've got rolling contracts. So what agents have now got in place is they've got a reminder on their system that every year they need to review the rent. And rent reviews are limited to once every year. And there's a process called a Section 13 notice to be able to increase your rent, and you need to give tenants a minimum of 2 months' notice for the rent increase to take effect. Section 13 notices have already been there previously, but they were only really used for periodic tenancies. If your landlord had or the tenant had a fixed term contract before, there was no need for a Section 13 notice because the new fixed term would incorporate the rent increase. So Section 13 notice, it isn't a brand new thing. It's been there already before, but it wasn't used much, whereas now it's going to be used on all rent increases. Tenants can challenge the increases at a tribunal, and then the tribunal will look at comparable properties and, check that actually this is a fair rent, and that can be challenged and reduced accordingly from the tribunal. Again, that tribunal has always been there, but previously when landlords and agents were serving Section 13 notice, it wasn't often that it was challenged with the tribunal. As a business, when we previously served Section 13 notices, we never had one go to a tribunal, but I think that will increase over time. But it's nothing to worry about, because ultimately, as a landlord, you just need to make sure that you're setting the rent to the market value. If you're doing that and you can demonstrate that with comparables, then you've got nothing to worry about. It's only if you're asking for more than the market rent, then yeah, you probably have a problem. There's also a ban on rental bidding. So previously, you could advertise your property, let's say, for £1,000 a calendar month, and a tenant could offer over the asking price, and you could accept that. Now you can only accept the asking price. You can't accept above that. Now, the next slide, please.
Yeah, no problem. Just a quick kind of point to add there to what Raj has said as well, which is, I guess it's coming back to the same thing really. Rent increases. This is an investment. Okay, most of you guys on today's webinar are buying these properties and building your UK portfolio because the investment matters. The numbers matters, of course. And are we going to want to continue increasing your rents every year? Yes, of course we are. But we're going to still make sure that this is an investment for you and move the rents forwards in the right way. But again, what this is doing, to go back to the point that I raised at the start, is it's cutting out the type of landlord that is willing to increase the rent by £300 per calendar month immediately after 6 months, during the tenancy. So again, it's stopping these bad and rogue landlords being able to kind of have total control on how they treat it, and it's giving in my opinion, what could be considered a fair playing field across the board here. Just to ask you one question, Raj, while we're on this slide, which is, if a tenant goes into arrears and decides to leave in month 4, what happens then? I think that's just relevant at this stage, following the last slide.
So if the tenant was to go to an arrears and just leave at month 4, essentially, you could then take them to court, I believe, but obviously they would have already been evicted, so there would be no section. You wouldn't serve a Section 8, I guess, because they would have left. Oh, sorry, we're saying that they've gone into 3 months arrears and then they've left. Okay, you would have then served a Section 8, and you would still pursue that through the court, even though they've left, and recover your rent arrears. Yeah, I'm assuming that's what the question was, that they're in arrears, but then they just, voluntarily left. You can still claim arrears, yeah.
Yeah, that sounds pretty much spot on answer, mate, to be fair. And yeah, like I said, that's actually a favourable position considering the worst cases. When if a tenant is in arrears and you do unfortunately have a bad tenant, one of the hardest parts of that process is actually getting them out of the property, right? So if they're voluntarily leaving, then we can go through the courts process to recover the loss of rent. If you have a rented legal protection insurance, that could have kicked in, and that can also protect you on that front. But look, it's a great question, and one that, again, a letting agent will have all the right compliance in place to protect you on.
Yeah, something to add to this as well, actually, that I haven't mentioned is, while we've got these, Section 8 notices, you can still negotiate with a tenant something different, but by not serving a notice. So it might be that, you want your property back, and you can just ask the tenant, look, can I have my property back, for X reason? And if the tenant agrees, that's absolutely fine. It just means that you're not going down the normal notice route, but you are coming to a mutual agreement with the tenant. So you might offer something to the tenant. You might say, I want to sell the property, but I appreciate, you've not been in here 12 months yet. So can we agree something where actually I get to sell the property earlier and you move out after, say, 6 months, but maybe I'll give you some, compensate you in some way. Maybe I'll give you a rent-free period, and you can absolutely do that. So I think that is something that, as agents and landlords, we're not really used to that, but I think it's something that we need to get used to, because I personally think that is going to be quite a big way forward to kind of like agree certain terms or getting your property back for other reasons, So it is worth kind of remembering that, and I think as agents, the landlord will get better at kind of dealing with them situations and negotiating them situations as well with tenants. Going on to the right to have pets. The tenants now have the legal right to request a pet, and landlords cannot unreasonably refuse consent for a pet to be kept in a property. So previously, we did have like landlords that, would just blanket no on all pets, regardless of what the pet was, So, are you going to be able to decline the tenant for having a goldfish? No, you're not. You're not really going to have a reasonable explanation on why you cannot accept that. There may be reasons why, a property might not be suitable for, a dog or whatever, or, other types of animals. And as long as you can justify that and reasonably refuse, then that's fine, but you can't unreasonably refuse. But to mitigate the risk, you can require that the tenant to have pet damage insurance, just to give you a bit of protection as well. There's also no blanket bans on tenants with children or those receiving benefits. That's now prohibited, and it's discriminatory. So you have to consider every type of tenant. Now, what you can do is, bear in mind that you might think, well, actually, a tenant with benefits going to be able to afford the property. Now, you can decline a tenant if they can't pass the referencing criteria. So if a tenant was to be on benefits, they would still have to pass certain criteria to be able to prove that they can afford the property. They would need to have a guarantor, they would need to be earning a certain amount within their benefits. So, if the tenant wasn't going to pass, you can pass the referencing, you can decline that tenant for that reason. Local authorities have the power to fine landlords for discrimination and, maybe discriminating on certain grounds for not accepting certain tenants. So you need to bear that in mind as well. And the next slide, please. So Awaab's law is something that was previously in just the social housing sector, but it has now been implemented to the private rental sector as well. And again, this is just there to protect tenants, mainly against like damp and mould and other hazards. But it's there really to just, it's there for the road landlords really, because, I don't know if any of you ever seen some of these programs with road landlords, but you see some absolute horror stories of the living conditions that tenants are living in. So this is just there to protect, them, all tenants now, where standard emergencies as a landlord, you have to respond within 24 hours. Standard issues 10 days. What I would say when it comes to damp and mould, if there is damp and mould, it quite well may well be that actually it's the tenant's living conditions that are causing the damp and mould, but you can't determine that until you get a damp or mould report. Now there are companies that do free damp surveys, so I would say always just get a damp survey done if there is any mould, and then that will highlight what's causing it. If it is a problem with the property, maybe the damp's in the bathroom and there's no extractor fan in the bathroom, it means you need to get an extractor fan. Or it might be that there is an extractor fan and the tenant's not using it. That will then highlight that it's actually down to the tenant not using things correctly, or maybe they're, trying their washing on the radiators or not opening the trickle vents in their windows. But by having that report, you can then, determine what the cause of the problem is and how you go about it, whether it's you on the landlord to resolve or actually it's on the tenant to resolve. But this is all about keeping good record, good record keeping for proving, certain issues and having evidence that you're dealing with it properly.
Yeah, I think sorry, Raj. I think with this one as well is it reiterates having an agent and a professional involved. Because look, you guys on the audience today are probably busy. You probably have your own jobs. You probably have your own lives. And sometimes it can be quite easy to miss that email or that call from your tenants. Totally understand that. But when you are trying to kind of abide these new laws, and if you've got a professional letting agent that's managing your property, they're going to have a team in place every single day to follow these laws. Okay, they're going to follow these timelines. They're going to follow exactly, and they're going to know exactly how to handle and how to advise you in the best way they possibly can. So, for example, Raj and his teams, they know everything about this new law that's come into place. So if one of your tenants has reported sightings of mold or damp, the first thing that they are thinking about is, okay, I have 24 hours or I have 10 days here, and this is how we're going to action it. So they will investigate and they will do this on your behalf, which I think is more important than it's ever been. And look, my experience working in lettings on the ground, I've seen some, as Raj has said, some horror stories. I've seen some landlords that are pretty terrible, and they've ignored the tenant for a year, and damp has got worse and worse and worse, and it's created health problems and whatever else. So just to be very clear, the reason that this law has come into place is to protect again against those types of landlords. But at the same time, I totally understand being a landlord myself. That can be very, very easy just to miss a text or an email from your tenants when you have your day job. So my advice from a neutral point of view here is if there's ever a time to have a professional letting agent involved, it's now, because they are going to know everything about these renters reform bill rights. They're going to know everything about this particular law, which I think was a really good time to mention this point. And they're going to protect you. They're going to give you the full coverage, the full protection that you're going to need. So I think, if you ask one of those people that are self-managing at the moment, maybe have a think about whether this is something that you can keep up within the new law.
Yeah, and Travis is right in terms of as a landlord. To be honest, if you've got a managing agent, everything I'm talking about today, you don't actually need to really be aware of, because it's good to be aware of it so you know and you've got the knowledge, but actually your agent should be dealing with every single aspect of this. So we have our landlords asking us now. Some of them are asking us, what are we doing? Are we implementing things? And of course we are, and we tell them, look, don't worry, everything there is for us to do, we are doing it already. They want to know the ins and outs of what we're doing. But then there's 90% of our landlords, actually, they're not bothered. They're just like, right, Martin and Co, if you're taking care of this, fine. I don't need to know. I'm not really bothered about the Renters' Rights Act. I don't really care to know any information about it, because it doesn't affect me, because you're dealing with it all for me. And I think that having that attitude is absolutely fine, because that's what you're paying an agent to do. You're paying an agent to take all of this hassle away from you. You don't need to know the ins and outs. So I think just make sure, if you've already got an agent, that they're aware of all of this, and any half decent agent will know exactly what they're doing, because this is a massive change, and they should have adapted their processes and learned all the new laws to be able to deal with this properly. Could I have the next slide, please? Okay, so yeah, just a few recaps here. So the information sheet deadline was 31st of May, but again, if it hasn't been served, just serve it now. It's better late than never. The Section 21 final expiry date. So prior to the 1st of May, landlords, if they wanted their property back for any reason, they could have served the Section 21. But if the Section 21, the deadline for enforcing that and acting upon that Section 21 is the 31st of July. And in later on in this year, there's going to be a mandatory rental database and ombudsman scheme for landlords. So landlords are going to need to be a member of an ombudsman scheme like agents currently are. And the reason for that is currently as an agent, we're part of an ombudsman scheme and the tenants can complain about us. But sometimes it's not necessarily the agent that's at fault, it's the landlord's at fault. And actually the tenant isn't able to complain about that landlord, whereas that's going to change now. The tenant will be able to complain about the agent and the landlord, or just one or the other, depending on who they think's at fault. Again, nothing to worry about. If you're a landlord that's doing things properly, or you're leaving it to your agent to do things, then actually the tenant can't really complain against you because you've done nothing wrong. If you've asked your agent to fix a certain issue, but the agent hasn't done it, that's not on you, that's on them. So yes, it's something that you need to be part of the ombudsman scheme, but I wouldn't worry massively about it as long as you're doing things right. Also, the rental database, I don't think things are finalised with it yet, but I believe there may be, there's talk about, every landlord registering to be on this database and maybe every property being on the database and certain certificates and compliance certificates being visible on this database. So I've heard there's talk about that. Just gives greater transparency so people can look online about the property and see that it's got all the necessary, gas safety or electric certs and EPC, any licensing, selective licenses that are needed. As an agent, we are going to help all our landlords. Once we know the full details of this, we're going to, landlords can register themselves with this, or we can do it all on their behalf. Just because there will be a lot of landlords that just say, look, right, I don't want to get involved. Can you just set all this up for me, and we'll be able to do that. And I think most agents would offer the same service. Can I have the next slide, please? Okay, so yeah, cost of non-compliance for this is £40,000 for a breach. So a breach might be things like, saying you're selling the property, you serve the notice, then you don't sell it, and you've essentially lied, you can be fined for that. So there is a thing in place where if you serve a notice because you say you're selling, then you can't re-let the property for 12 months after. And that's a way for the government of interviews to get people, landlords around, pretending that they're selling the property when they aren't. So they've implemented big fines up to £40,000 to prevent landlords from doing things like this. And then £7,000 is kind of the standard penalty. And then you've got rent repayment orders where basically they can order that you repay your tenant back, up to 2 years worth of rent if you haven't met your obligations. Next slide, please.
Okay, great. Look, Raj, that was really good to hear all of that, and even for myself, that's had 8 years of experience in lettings. It's when you're not on the ground and not working in it every single day, you can quite quickly fall behind, and that's why I advise all of my clients. No matter how long you've done this for, no matter how many properties you have. I'd like to think I know more than most about it. I've worked in that industry for 8 years. However, there's a lot even there, on the webinar today that I didn't quite know was on that extent. So I think it reiterates the importance here of having a professional agent involved that are there to protect you. Remember, if you have the right letting agent involved, that's their job. Their job every day is to manage your property, to protect you, to guide you, and to give you the right insights in how your property should be managed. So look, it was very good to go through that kind of webinar today on the renters reform bill, the biggest change in the lettings market that we've seen forever, which is why it's so important to do a separate webinar for it. I think what we'd like to do now is invite any questions. There have been a few already. As you know, we are live. We're here to answer as many questions as you guys see fit. I am very conscious of the time. I know you've spent the best part of 45 minutes so far listening to us, so we'll probably give it kind of 5 minutes worth of question answering. So yeah, please feel free to ask your questions in the Q&A box below, and we'll start answering them. So I have a question here, which is, hi, can a landlord increase the rent during the first 12 months of rent, for example, 3 months after the beginning from the rent starts, or once the first year has elapsed? I think I could probably answer that one quite quickly. That the rent can't be increased within the first 12 months of the tenancy. You have to wait for 12 months before you can increase it, and then it's just once per annum that you need to increase the rent. Like I said, the whole point of that is for fair play towards the tenant, that there's landlords out there that have moved to tenants in, and then a few months later they've tried to spike the rent immediately, and of course that creates an unsavory position for a tenant who's, of course, when they decided to sign that contract to move in, they've made a decision based on their funds and their finances in order to afford that rent. So I always think if you're going to do that, you're risking the tenant not being able to afford the rent. And I think it's probably the wrong approach anyway. But yeah, to answer your question, the Renters Reform Bill will protect against that, so you won't be able to do so. I have one here for you, Raj, which is what happens if I do not conduct a proactive audit for the damp and mold?
So, Travis, so say that again. It cut out for a second.
It's all right, no worries. So I just said, what happens if I do not conduct?
Sorry, it cut out, but I think I got part of the question anyway. But yeah, if, in regards to if you do not conduct get an audit trail for damp and mold, then you could essentially be in a position where you've got to, you could essentially get fined depending on what the issue is. So I'd probably say just cover yourself and get a damp and mold report. Like I said, you can get them for free. But there are companies out there that do them for free. There are companies out there that charge around £100. Personally, but I'm a landlord myself, and I use a damp company as and when a tenant reports damp, um, and I actually pay. I would rather pay a company to do it rather than get a free one, just because I think if I'm getting a free one, they're always gonna they may or may not try and make issues off the back of it so that they get work. So I just prefer to use a paid one. And £100, it's not a lot of money. And to be honest, on the occasions when I have had it, the damp and mold, it has been down to the tenant, not leaving trickle vents open and drying, the damp assessor's gone there and he's just enclosed drying on the radiators and the windows aren't the trickle vents aren't open and the bathroom extractor fan is turned off. So straight away my damp report has mentioned all of these and I've just been able to turn it around on the tenant. Ultimately though, at the same time, it might be that there's an issue with the property. And if there is an issue with the property, I need to know about it because I do need to resolve it, and that's my job as a landlord to resolve. So yeah, I think damp and mold inspection reports are really, really important to help me out.
Yes, some things are just worth paying for. And look, the whole point of this is about protecting yourself as a landlord, protecting yourself as being in that category of the good landlord that wants to do the right thing. And if you're doing that, then you'll be fine. Okay, so it's about protecting yourself. It's about listening to the advice from the agents when they give you advice as to what needs to be doing. Trust that agent, trust the people you work with, and things will naturally be okay from there. I've also had a question, which is also since the landlord will now have 2 months to find a new tenant, what do I need to set in the agreement to enable reasonable new tenants to see the property? Look, just probably a quick answer to this one. I guess what my advice would be is to advise your letting agents, which they should be doing anyway, that when the tenant serves their 2 months notice, they are starting that marketing process straight away. So they are starting that marketing process to try and find you a tenant to make sure that your void period is minimalized by as much as possible by immediately getting that property online and doing the relevant marketing strategy in order to find you with the right tenants. I also think what's important there is making sure that when your tenant serves a notice that your agent is advising them that they need to provide access for viewings. So if you have an agent that are responsive and they're proactive, they will be doing this anyway. But I would certainly kind of give them a nudge to make sure that if a tenant serves a notice, they are in control of that process. Make sure that they've agreed to their viewing time slots and make sure they've agreed to kind of market that property immediately after the notice has been served. I have another one here, which is there a limit to rent increases for existing tenancies?
No, there's no limit. It's whatever market rent is essentially. So, that yeah, you can increase it to what you want within reason because I mentioned the in reason because the tenant can challenge it. So you don't want them to challenge it. So what you want them to do is realise actually this is how the agent has calculated this rent. Maybe there's other apartments in the building and the agent can provide comparables. Or if the agent's done all that, tenants not going to bother challenging it because why would they? You've demonstrated it's fair. But yeah, I think the main time the tenants are going to challenge rent increases is when they're unfair and there's no comparable evidence to say that that rent is a fair amount. But ultimately, if you are charging half of market rent at the moment, so you want to double your rent to market rent, you can move.
Yeah. Okay. Yeah. That's a great answer there, Raj. And look, this again reiterates that doing the right thing when you are increasing the rent, don't just call the agent to say I want to increase it by £300 a month. Do your due diligence, trust their advice, look at what the market current rates are, and if you are way behind, then let's get it closer. But this is again about finding the happy medium between both. That leads me on quite nicely actually to a question here, which is it appears this is all about tenants' rights, what rights the landlords have. Look, it's a great question, and I probably disagree with an element of it. I think this is about both. I think this is about protecting landlords as well as tenants, but it's about doing things more equally, doing things fair. If you are a good landlord and you want to just grow your portfolio, you want to increase your rents every year, you still have every single right to do so. Okay, this is cutting out the bad landlords that are the problematic ones that are not looking after their properties and therefore not looking after their tenants who then can't find somewhere else to move and live. Okay, so this is all about trying to find again a situation within this world where tenants feel comfortable and landlords are still kind of enabling this investment to work for them. But look, great point, and I wanted to kind of answer it live and discuss it because I know at times and some of the feedback that I've had, people seem to think that this is all designed to support tenants, which I understand that approach completely. However, when we look at the bigger picture here, if you are a landlord that does the right thing, you won't see any difference. You won't have any effects. You won't see any problems. This is really going to hurt the ones that are the bad tenants because they're going to have the ability for their tenants to leave sooner. They're going to have more penalties for problems. So again, this just reiterates that you need to do the right thing. You need to look after your properties. You need to treat your rental properties as if it's you living in them. If you do that, you'll be absolutely fine. We have another one here, which is with the renters reform, sorry, hang on, let me read it right here. With the reform, does it mean that I do not need to get a tenant to recontract, just wait till the new tenant serves notice and start looking for a new tenant again?
Yeah, that's right. So you don't need to sign a new contract. Your tenancy agreement on the 1st of May would have automatically converted to an assured periodic tenancy. You should have served, obviously, the information sheet to the tenant, and that basically explains to the tenant that their contract has changed and it advises them on their notice period. So at least if you've served that properly, because we are getting tenants now, they're trying to give us 1 month notice, and we're referring them back to this information sheet that we served and said, have you not read it properly? Because actually it does say on there 2 months. And then the tenants are kind of like, yeah, okay, I didn't read it properly, but yeah, it's very clear there, and they're accepting that it is a 2 month notice period. So yeah, very important to serve that notice, that's that information sheet, even if you haven't done by the deadline, still get it served on the tenant now.
Amazing. Okay, guys. I mean, look, there's been a lot of questions there, and there are a few more. So, I mean, the next steps here in regards to what we're going to look to do is this. So, what we're wanting to do here is we're wanting to provide clarity, which is totally free. You can either have a consultation with myself, or you can have a consultation with Raj. There's no commitment or no obligation with this. This is about having a landlord, having one of us as property experts on the other end of the line, and we're going to give you as much honest feedback about how this can work. If you have a property portfolio and you want to ask how to structure that and how to best work it within the constraints of Renters Reform Bill, we can help, we can advise, and we can support you. If you have a property portfolio already, or a couple of properties, or a single property, and you want to move to a more professional agent, I'm sure Raj will be more than happy to speak to you about that as well. But look, we're almost at an hour. What we're going to actually do here is I'm just going to send a poll on the screen. which is basically just to help us understand where you're at with your journey. Would you like a consultation? Would you like one with me? Would you like one with Raj about the rental aspect? And yeah, like I said, it'd be really good to kind of speak to as many of you as we possibly can and hopefully give you the confidence on what's happening here. There are big changes, big changes happening, but that is not a negative thing, and that's what we're here to do. We're here to guide, we're here to support you, and we're here to give you as much of an understanding of this as possible. So if you could please fill in the poll before you leave, that would be amazing. We also have a recording of this webinar that we'll be more than happy to send out. So if you would like a recording, please request one after the webinar, and we can send out a live recording of the webinar for you to send across to anybody or to have a look at. But look, really appreciate everybody's time on the webinar today. Raj, thank you very much for joining. It's been great to hear your expert advice, especially being on the ground and involved in this on a day-to-day basis. And I hope everybody found it useful. Like I said, what we're looking to do here at Joseph Mews is to give our clients and to give people around the world as much education and support as they possibly can. And there's no better than when legislation comes in like this to have experts that can come on and talk about it. So it'd be great to speak to as many as you as we possibly can. And yeah, if you need anything from me, please feel free to ask. And if not, have a great rest of your day, and I look forward to catching up with you soon. Take care.